Hello, everyone. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. In tonight's event, you will have the opportunity to speak with a panel of attorneys to get insight and guidance on estate planning, wills, and probate. Before we begin, I would like to share a couple things about Zoom. Please keep in mind that everyone's videos besides our speakers will be turned off. You will be muted unless you are asking a question, then you may unmute yourself. If you have a question and would like to speak, please use the raise your hand feature and keep that on. If you have, the way that you can see the raise your hand feature is if you click on reactions located at the bottom of your screen. Also at the bottom of your screen, you'll see a chat feature. I'll be using the chat to list by number whose turn it is next. Please respect others and wait to be called on. We want to avoid people speaking out unless it is your turn. For those who are calling in, if you want to speak, please press the unmute button. We will see that and add you to the numbered list. Unfortunately, you cannot use a chat feature, so we'll use the unmute as a way of saying that you're next. Once myself or the moderator calls on you, then you may speak. Without further ado, I'd like to begin by introducing Desiree Sanchez. She is our moderator for tonight's event. Thank you so much for joining us. I'll go ahead and turn it over to you.
Thank you, Rebecca. Good evening. My name is Desiree Sanchez from the Sanchez Law Group, PA. I practice in the area of estate planning, wills, and probate, and I am a member of the Orange County Bar Association. I'd like to thank you for attending our Ask a Lawyer event sponsored by the Orange County Bar Association and the Orange County Clerk of Courts. Before we get started, allow me to give you a little background about the Orange County Bar. The association has been around for 85 years. In addition to serving the needs of our members, one of our goals has been to reach out into the community and provide services and programs that will benefit Central Floridians. Some of our programs include our members' pro bono work with the Legal Aid Society of the Orange County Bar Association, our loyal referral and information service, our last week program for school children of Orange County, and our free citizen dispute and family law mediation program. The citizen dispute and family law mediations are facilitated by an impartial professional mediator who listens to both sides and encourages a resolution that is satisfactory to both parties. By reaching a settlement, both parties avoid court costs and uncertainty of trial outcome. This is a free program for anyone residing in Orange County. Tonight's Ask a Lawyer event is just one of those programs. And we hope you feel free to ask any questions you have about estate planning, wills, and probate. Orange County Bar Attorney Skiles Jones of Patriot Legal Group, myself, and there may be one other attorney joining us, will help guide you through some of the issues that you want to know about. Tonight's event will be recorded and shared on the Orange County Association's Facebook page, so please be sure to like the page if you are on Facebook. I would like to introduce Roberta Walton. Ms. Walton is the inaugural manager for the Self-Help Center and the operations manager for the Orange County Clerk of Courts Family Services Division. As the Self-Help Center manager, she oversees services offered to self-represented litigants and interested in family law, landlord-tenant law, and small claim cases, to include attorney consultations offered in collaboration with the Orange County Bar Association. So without further ado, Roberta Walton.
All right, thank you so much, Desiree. I appreciate that warm introduction, and to Attorney Jones, to you as well. Good evening, everyone, and welcome to another fun-filled event hosted by the Orange County Bar Association. As Attorney Sanchez stated, my name is Roberta. I was listening to that intro thinking, boy, I need to update my bio because a couple of things have changed, namely my role. I still affiliate with the Self-Help Center, but no longer tasked with it. But I'm going to share some details regarding the Self-Help Center with you tonight. Hopefully, I'm not technically challenged this evening and I can share my screen. So let me attempt to do that. All right, am I sharing? No?
You are.
Yep.
Okay, I can never tell whether or not I got it right. So first things first, just a little bit about the Orange County Clerk of Court Self-Help Center. Are you seeing that screen?
Roberta, I don't see that screen. I see your email.
Okay, that's what I thought.
You might need
Let's
to
see.
reshare.
Let me try to reshare.
Or you may need to share a different screen.
Okay. All right. What about now?
Roberta, you're gonna have to click on stop share and then reshare.
Okay, hold on.
There you go.
Did I stop it?
Now I can see your PowerPoint.
Okay, so you can see it.
Yes.
All right. Okay, so I told you I was technically challenged.
No
Everyone. Okay, so just a little bit about the Orange County Self-Help Center. First of all, this was an initiative that was put forth by your Orange County Clerk of Courts, Tiffany Moore Russell, back in 2015. She, with her resilient background in legal services, where she actually used to serve as a legal services attorney, she recalls that moment of not being able to assist certain individuals for whatever reason, if it was topic related or if it was because they operated outside of the income range. And this was something she always wanted to put forth, was provide services for those litigants who wanted to represent themselves in court without the representation of an attorney. So when she was elected to the Orange County Clerk seat back in 2014, she hit the ground running to get this program up and started. And in 2015, opened the doors to the Orange County Clerk of Court Self-Help Center, where we provide assistance to help streamline the procedural process for all individuals interested in representing themselves in the areas of family law, residential landlord-tenant matters, and small claims actions. At the Self-Help Center, we offer attorney consultations, which is a wonderful partnership that we've established with the Orange County Bar Association, so thank you. Where we have a group of licensed attorneys here who are all members of the Orange County Bar Association to rotate and provide one-on-one services to individuals who are interested in scheduling an appointment about one of the related areas we talked about tonight: family law, residential landlord tenant matters, and or small claims. And I must tell you, because I don't want to eliminate the element of surprise, these consultations are limited to $1 a minute. So Clerk Russell really wanted to make sure that the opportunity to sit down and receive some guidance about how to represent yourself in court was available to anybody who needed it, who had an action that they'd like to discuss here within our circuit. In addition to the attorney consultations, we offer, I'm getting all tongue-tied, notary and copy services. It's also a full service center where we have 5 full service deputy clerks there to provide triage services to help. We sell forms, but for you to complete your forms and for those deputy clerks to, again, answer any questions that you might have about the forms and make sure that those forms are complete and ready to file. And guess what? They will file them for you right in the Self-Help Center. So again, we have the full service document library where we offer forms related to the case types that we service. And we have several public computers there for individuals to come in and do their own research, to do their own drafting, and to really and truly empower themselves as they go on to represent themselves in court. Here, just wanted you to know, where can you find out information related to the Self-Help Center? You can go to our website, www.myorangeclerk.com. Again, that's www.myorangeclerk.com, and look for the Self-Help Center tab. That tab will lead you to our website, where it gives you all of the information unique to the Self-Help Center here with the Orange County Clerk of Court. It gives you where we facilitate our services, which is here in the Orange County Courthouse on the 3rd floor in room 340. It gives you our contact information, our office hours, and again, it notes what services we offer within the Self-Help Center. Here I have a little quick cheat sheet for you. It kind of indicates what cases we handle and what cases we don't handle. So tonight you're here to hear a little bit about probate and wills and trusts. We do not handle those cases in the Self-Help Center, but we do handle family law, residential eviction, and small claims, which again, you might have a similar scenario or similar case matter that's related to what you're here to hear about tonight. Again, just giving you those locations. We do have a temporary location that's not up and running right now. We have not opened our Popka branch office up yet because of the pandemic. That is coming forward. Right now, we are solely at the Orange County Courthouse, and all of our appointments right now happen to be virtual appointments. So you don't have to leave the comfort of your home to still have that one-on-one virtual experience with the licensed attorney to discuss your matter. Again, as I stated, the appointments are $1 per minute, and they're done in 15-minute increments up to 1 hour a day. So you can schedule a 15-minute, a 30-minute, a 45-minute, and a 60-minute appointment per day. So you can access that again right here, www.myorangeclerk.com, and that will take you to our website so that you can schedule your appointment online to meet with one of our licensed attorneys. Again, I've provided our contact information here. And again, we are so happy to help those litigants who are interested in representing themselves for whatever reason. We ask no questions because we do pride ourselves on our full service Self-Help Center shop. If you have any questions for me, please feel free to, I believe, post them in the chat room and I'll be happy to answer your questions. I'm going to stick around a little bit for you, but enjoy the rest of the presentation this evening.
All right, so okay, there we go.
There we go.
All right, so at this time, I will open the floor for questions regarding estate planning, wills, and probate.
All right, and our first attendee with a question is Charles. You can go ahead and unmute yourself if you would like to ask your question.
Yes, I have a question. My mother died in April, and she has some properties down in Florida. And my question is, can me and my family, if we all agree to sell those properties down in Florida, can we just go on and sell it without going through probate court, or do we have to go through probate court?
Great question, Charles. Skiles, would you like to answer that one?
Sure, absolutely. And Charles, first off, obviously we every time we talk about probate, it's never a fun subject. So going through it is one of those things that there's a process involved with that. And we are sorry to hear about your mother passing.
Thank you.
Yeah, the question that you have is in regards to selling property that is owned by your mother. I want to say the short answer is no, you can't sell it without going through probate because the ownership of that property is in your mom's name. And once she passes, you as the beneficiaries or heirs of her estate, even though you may be entitled to ownership of that property, you don't have title to it. You don't have the authority to sell that property. So that's where the probate court comes in. And probate's not a scary process, especially if everybody is in agreement with everything. We have tons of probate issues that we deal with where the kids come to us and say, there's 3 kids, there's 8 kids, whatever it is, and they're all in agreement. They want to get it distributed to one of them, split it, however you want to do it. But the Florida laws do say that you have to have probate to make the ownership pass from your mom's name to the kids' names. And then after the probate order comes through, then you have the ability to sell it for, whatever you guys agree to sell it for. But the answer to your question would be yes, you do need to go through probate. Does that answer your question for you?
Yeah, I should have mentioned that one of the properties have my name, and I had right to survivorship to that one property. So I was wondering if that one property have to go to probate also.
And that does raise a different issue. And just for folks that don't understand or that terminology, what that means and what you're telling me is that you own the property with survivorship rights, and that is labeled on the deed specifically that way, that says rights of survivorship. When that happens, when one of the folks pass away, then that person's name is removed from the deed by operation of law. And to do that, you would record a death certificate with the county. So whatever county that property is located in, you record that death certificate. And by doing so, that removes that person's name from the deed of the property, and whoever is left on the deed would then have ownership of it. So with that property, I would say the answer would be no, you don't need probate, again, as long as it's spelled out properly on that deed. And we'd be happy to review things for you. And there's tons of folks that can do that type of thing. Most of the probate attorneys do free consultations and such to kind of get you in the right direction, and then go from there.
And Charles, just to add to that, if that property is the only property your mother had, it may be quicker than you may think. There are certain processes that you have to go through, but if it is paid off or if it's homestead, it's actually a quicker process. So, but doing it by yourself sometimes with probate in particular can be quite difficult. So definitely get an experienced probate attorney. All right, so you're very welcome, Charles. The next person is, I want to say Paul or Saul. Is that correct?
Yes, I'm sorry, it's Paul.
Okay. Okay, Paul,
Hi,
what is your question today?
My wife and I, we have started the process. We went through a Susie Orman program, and we've put in all the data and everything. And I've heard about a ladybird. If you have a valid will, is it necessary to have a ladybird
Great
to
question.
transfer ownership of your home to your heirs?
So Skiles, if it's okay, I'll go ahead and touch on this one. So I'm a proponent for both. But a ladybird deed, the purpose of a ladybird deed is to avoid probate.
Mm-hmm.
A will is advantageous because many people forget to include assets or to put an asset in a trust or in a ladybird deed. And so that will is a safe haven to ensure that your assets pass the way you want it to pass, what your intention is. But a ladybird deed, I'm a big proponent of ladybird deeds because it's inexpensive and it can save the family thousands of dollars. Skiles, do you want to add something to that?
No, that's a great answer. A ladybird deed does do that transfer on death process. So again, like I was saying to Charles earlier, me and you own a piece of property together you own the property. You've named me as the person to receive that property after you pass away on that ladybird deed. Then I would record your death certificate and I would then have ownership of that property. So that's the logistics of how that would work. Now naming that, definitely talk to somebody to talk to an estate planning attorney to kind of get the right verbiage on there for a ladybird deed, because I've seen some of them that half say the right things and half don't say the right things. So it has a couple of issues on there as well, but it is a valid type of way to avoid having to go through the whole probate process.
But again, if you have your home allotted, or I don't know if that's the right word, designated to your heirs, your children, is a ladybird just extra, or just does it make the process easier?
It avoids probate altogether. So many people think a will in itself avoids probate, and it does not.
Okay,
A ladybird deed does. But it only deals with that one property. And that's the reason why I always tell people do a will as well. I hope that answers your question. A ladybird deed is definitely the way to, it's the cheapest way to transfer an asset to one of your family or, to a person without probate.
okay, that answers my question. Thank you.
Okay, you're welcome. So we have somebody with a 12014 or a phone number on here. I won't say it out loud. If Rebecca, if they can be unmuted.
Yes, I think that person left. If your phone number started with a 120 and you were asking a question, but you changed your name, please let us know. But I think I saw them leave. So our next person is Trisha. Oh, Trish, sorry.
Hi, I have a question. Like, we already had a divorce, and now my ex-husband is not paying me the alimony, and that's non-modified alimony. What can I do?
So Trish, we would love to have that question answered for you, but tonight is not addressing family law type matters. However, the Orange County Bar Association has a referral program that could be of help, and Rebecca, I'm sure, can share a bit more about the program.
Okay.
Rebecca, you there?
Yes, I'm so sorry. I'm going to add it to the chat, and I'll also be sending an email to everyone following the event with resources to get more information in case you have any more questions.
But Trish,
Sure.
that's a great question, and definitely the Orange County Bar Association can get you to a person that can assist you. Okay.
So I have, okay.
Did you want to share anything else?
No, thank you.
Okay.
Yeah.
All right. So we have a question from Frank, and he actually placed his question on here, so I'll read it. How can I create a will that will be assessed in case of death? I do not trust bank safe deposit boxes since I was robbed by Trustco Bank in 2017. I need to replace that will. Skiles, you want to start on that one?
Absolutely. Frank, are you able to hear us?
He may not want to talk.
He may just be in the chat. Okay. So I'll answer that question there. So safe deposit boxes are one way to hold a will because if a fire happens, a flood, who knows what could happen in the house if you just keep your will laying on the kitchen counter. That will could disappear after you pass away and your wishes would not be known. So putting it in a safe deposit box is one way to do it. The problem with that is nobody has access to your safe deposit box after you pass away. So, if you have your son or your daughter or a friend that you said, my will is in the safe deposit box at Bank of America or wherever it is, go down there and get it after I pass away, they're not going to give it to them. So they'd have to go to the probate court to ask the court for permission to go get that will. Then they can go get the will. Then we'd see what's actually on the will. So it is a whole process there. There's other ways that I typically would recommend my clients to deal with a will. I usually say, buy you a fireproof safe or something like that and put it in the house is probably the easiest way to do it. And then let the people know that are in the will, or at least one or two of them, that the will is in my safe, in my closet, or wherever you're putting it. The combination is 1, 2, 3, 4 in case something happens to me. But there's not a way in Florida, at least not at this time, to record a will prior to somebody's passing. So Florida does not, and most states do not, have a way to take that will and record it with the state or with the county. So that there's the clerk of court is not going to accept that will prior to someone's passing. So you have to keep it on your own. There are services out there that can keep an electronic copy of it, but electronic copy is not necessarily going to be valid. You need the actual original will after you pass. The original will is what needs to get admitted into probate. At least at this time, you got to have that original will or someone that was present with that original will. So there's a number of issues that come up with that. But nowadays, safe deposit boxes are really not the most ideal way to hold a will. Find a more secure way to do it at the home is usually my recommendation. Desiree, any other recommendations that you have?
So what I typically share with people that, having at least 2 or 3 originals, like, one in a safe deposit box, one with the attorney's office, and even an attorney, even if they have a copy, they can help to reestablish the will. And then another being with the actual personal representative that you're identifying to administer your estate upon your death. Someone that you really trust, that knows that, that will really move forward with your intentions. It's tough because with a safe deposit box, you actually have to start without a will when you start the probate and then move it to a will. So it can be complex, but if it's there, at least if everybody else loses it, you at least have an original there. So that's, Frank, does that help?
Can you hear me now?
Yeah.
Yes, we can hear you.
Okay, good. Sorry, I had my mute button on. I didn't realize that it doesn't show on the screen. So what you're saying is I have to have an original copy that is what, certified or authenticated by somebody in paper with some kind of ink stamp on it, in addition to that I store in the safety deposit box?
Well, you don't have to have more than one. One is fine. What I'm sharing, so we had a situation recently where the person could not find the original will. We contacted the attorney's office. So you having, someone you trust that can reach out to the firm that did your will, will help to reestablish a will, even if you lose all the originals. So that law firm can notarize and witness that, yes, they did your will for you. Yes, these were your intentions, and they can reestablish the will, even if it's a copy.
So I can't create my own will and have it notarized and store it someplace. I need to have an attorney certified.
No, you do not. That's just, most people have an attorney prepare a will, but you don't need one.
Okay, so if I have my own copy, as long as I can get that to the person that's my representative in case of my death, they can carry forward with that copy.
Correct. You just need to make sure that it meets all the criteria under Florida law. I just came across another will that was not enforceable because it not meet the criteria. So that's kind of you have to kind of do a cost benefit analysis to see what works best for you to determine whether, you want to do the will yourself or hire an attorney.
And what law is that needs to be followed?
It's just the law on wills, just what is required to be, like what's required in order to have an enforceable will.
Okay, so I can look that up in the Florida statutes.
Right, correct.
I have another question I think it was I'm the representative from the Self-Help Center. I went through the Self-Help Center to do a small claim and got all the way to the end of it. And during the final case review with the judge, she didn't reimburse me my full amount of expenses that I had to go through in order to get my possessions out of the bank, that they, attempted grand theft larceny with my possessions. Is there anything in the self-help that will prevent other people from getting a deficient reimbursement like that? It cost me over, $500.
So Frank, unfortunately, this evening, we're not addressing matters that do not relate to probate and wills or trusts. So my recommendation is to contact the self-help tomorrow.
Okay.
And ask them how it is that you can obtain, reimbursement, and hopefully they can get you an attorney to help you.
Okay, thank you.
You're very welcome. Eileen, you have your.
Oh, well, sorry, we're gonna go back to J Rod.
Okay.
Joseph?
Hello, good evening, everyone, and thank you for taking time out of your busy days to come and help us all with our questions. My question, I guess it's fairly simple. It's, what do I need to establish a trust? My wife and I do have a will, but we have a special needs son. So we were thinking, in case that our demise was at the same time, how can we establish a trust to basically help him out through his life?
Great question. Skiles, do you handle special needs trusts?
Yeah, so let me tell you a little bit about that. So just so everyone understands, when you have a special needs trust, that there are some specific criteria that you need to put together to make sure that when you put that trust in place, that the child is taken care of after you pass away. So there's a number of different things, and obviously we're not going to get too into the specifics of it, but you can set up your trust for yourself to make sure that you can put your house in it, you can put your bank accounts, your stock accounts, all that good stuff into it, and you would manage it during your lifetime for your benefit. And then if something happens to you, it converts over into that special needs trust for, was it your son? Was it?
Yes.
So it'll convert over for your son. You can also, in that same trust, put additional people in there. So if you have additional children that are not special needs, you can say, I want this percent to go to, say 25% goes to these kids over here because, to give them a little bit of something, and 75% goes over to the special needs child, so that that person is taken care of for the rest of their lifetime. Your question is, what do you need to establish the trust?
That's correct.
And are you talking about what type of assets do you need, or what do you mean by what
I guess any type of paperwork, like if we have to present something that shows like his paperwork showing his disabilities and things of that nature, or is it just, do we just walk into an office and basically say we need a special needs trust, and the attorney basically just takes us at our word? I don't know.
Sure, understood. And if it's something that you're setting up for yourself, there's nothing specifically that is needed in regards to proving what disability is there or anything along those lines. There are some requirements when it comes to setting up a separate trust now for that person's benefit. But what you're asking for is a trust that happens after you pass away for his benefit. Is that right?
Yeah. Correct.
Yeah. So with that, you would just basically set up your trust with some special needs language in there, which kind of outlines what happens after you, your spouse, or whatever would pass away, so that it gives that guidelines after you've passed away. But during your lifetime, there's not really any proof of what his disability would need to be, or anything along those lines, because you would be in charge of the funds for your benefit, and you have the authority to spend money on your son as much as you'd like, because you're in charge. Excuse me, you would be in charge of the trust during your lifetime. After you pass away, just have to have that specific language in there to make sure he's there. So getting with an attorney to set that up is best. I have seen that there are ways that you can find some of these things online. My experience with some of the trusts that are online is it doesn't cover all the things that you possibly need. And the after someone passes away is not the time to realize that oh my gosh, it really didn't meet what your intent was, and your son's not protected like you thought it would be. So it's usually best to have that consultation with an attorney to kind of see what that attorney can help you with, get you in the right direction, and make sure that you get that peace of mind for after that person passes, or after you pass away, so your son is taken care of, and you're good to go.
And J Rod,
Okay.
just to
Yes, ma'am.
add to that, J Rod, So there's not many attorneys that do special needs trusts. And I'm sharing that with you because that's how complicated it is. So I know Skiles was talking about a trust first, and then, upon death, it can go into special needs trust. Yes. An alternate is you could also have a pour of a will into a special needs trust. So you can have a will that basically states that the special needs trust is the beneficiary or one of the beneficiaries. So just to give you that option that, yes, you can establish a trust while you're living, that then the beneficiary is the special needs trust, or a pour of a will that pours over, like it's literally like pouring your assets over into a special needs trust. But it's very complicated, and I would recommend you go to somebody who's experienced. I don't do special needs trust. If Skiles does special needs trust, I would definitely recommend him or an experienced special needs attorney. Okay, I hope that helps. I'm going to assume so.
I'm sorry, that's my wife, so she just wanted to put something.
Okay.
Yes, I have. So first we'll be doing a trust while living. Then create a portable will that will be turned into a special needs trust. Is that correct?
No, so you have two options. You can do a trust during your life that then the beneficiary is a special needs trust, or you can have a will where you do nothing. Your assets remain in your name now, and upon your death, you have the beneficiary as the special needs trust. So it's not both.
And the other question is there any state agencies that oversees any of these special needs trusts? If there is any other siblings or entities?
You said siblings or entities. What do you mean by that?
For example, if he outlives me and my husband, and then he has no other relatives, does the state becomes overseen over this account or no?
Right. So for special needs trust, you have to have a third party be the trustee for your son. So let's assume that the two of you pass away and he outlives you. So whatever assets you would have would then pour over into a special needs trust for him. Then somebody would be the administrator of that trust. And there may be a way to put a family member in charge of that. And there may be a way to put a company in charge of that. Let's say like Vanguard is a online investment brokerage house. They can be a trustee of this type of thing and invest the money and such. There are many different agencies out there that can be a trustee for you. And that person would be in charge of distributing the funds for his benefit for the remainder of his lifetime. And by doing so, that also helps to it helps to protect those assets from any type of I'm going to say creditors, but that would be it's hard to understand what that means. But if you were just going to give that money to him directly, okay, so let's say you did not have a will that created a special needs trust, or you did not already set up a trust during your lifetime. And what Florida would do is Florida law would say that he would inherit your assets. So whether it's $10,000 or $10 million, whatever it is, your assets would go to him. That may disqualify him from being able to receive Medicaid, because Medicaid is a very large benefit for someone that has a special need like that, and Medicaid pays a lot of expenses on a monthly basis. However, you have to qualify for Medicaid, which means you can only have so much income per month, and you can only have so much in assets. And it keeps changing every year. Of course, it goes with inflation and such. But if you don't qualify for Medicaid, then it's going to drain those funds out of it's now his funds, right? It was your funds, now it would be his. And it's going to start draining those funds for paying for medical expenses, or paying for anything that might come up that should have been paid by Medicaid. So putting a little bit of money now into setting up a trust for him would, in the long run, make your money last longer for him, because it would be more supplemental expenses that it would pay for, not necessarily every little tiny thing that, or for medical expenses and such. Again, like Desiree said, it's a very complicated manner or a complicated matter when you're dealing with a special needs trust. And also, like she said, that you're either setting up the will now that says, when I pass away, I'm creating the special needs trust, or you set up the trust now and you start moving all your assets into the name of the trust so that it transitions a lot easier after you pass away. And I say you as in both of you collectively.
So Skiles, I'm just going to, I know you can talk all day about special needs trust and really enjoy and be passionate about it. J-Rod and your wife, I would highly encourage you all to seek out an attorney who, like Skiles, that knows the law, knows how to protect your son. I have a special needs son as well, so I'm passionate about that. But you do want somebody who has that experience, okay? I'm just having to move on a little bit, just for time purposes. All right, so I think Eileen may have been on there with her hand up. If Rebecca, if you can unmute her.
Yes, yes, Eileen, you're next.
Hi, I'm the daughter of an 88-year-old man. He is currently diagnosed with multiple medical issues that are very severe. He has dementia, he has Parkinson's, and unfortunately, he's about to be diagnosed with cancer. So I am in the process of trying to update all of his paperwork. 15 years ago, when my mother was alive, we did the will, the living will, the quick claim deed, the power of attorney, and all of the paperwork. But that paperwork is extremely outdated because my mother's name is still listed as the initial beneficiary, and then I was listed if she was unable or unwilling. So technically, I could still use this, but it's very outdated. So I am in the process of redoing everything, but there's a lot of complications with this because he is going to be needing major care, probably in some sort of home setting or like what do you call it? You know, where an elderly home where they have special care. The name escapes me right now, but
he taken up hospice.
No, not necessarily before that.
Assisted living facility.
Assisted living, yes. That's it. Now, at this point, he is unwell enough to benefit from going there, but he adamantly refuses. So right now we are doing home health care out of his own pocket, which is costing an incredible amount. He is of limited funds and limited assets. I've had to sell his car to pay for that. At this point, the only other thing he has is his home. So now that I am changing all the paperwork so that I don't have to do probate and I'll be able to sell his property to pay his assets in the event of his death, I've run into a complication because I have the opportunity to put my name on the deed. So, you know, to do the ladybird deed so that I won't have to do probate. But right now the home is in a trust. So if I remove it from the trust and put it in a quitclaim deed, that helps me now in the event of his death, but that does not help him in the event that he needs Medicaid to be able to pay for care in a home should he need to go there. So my concern is, do I put my name on the deed now, but then that would create serious complications with him being eligible to receive benefits for that care. But, I don't know. I don't know what to do.
So my
Desiree,
question to you, Eileen, is whether or not he is of sound mind and body right now.
Legally, yes, but there are severe deficiencies here and there. But because he is still able to communicate with the doctors and such, they are saying that I can only advise them for his medical care, because my power of attorney still says that he has the right to make his own medical decisions unless he is unconscious or unable to do so. So I've run into a couple of situations when we've gone for medical care and he didn't want to do a particular test or something like that because it was uncomfortable, and he refused, and they say that he still has the right. Because I thought of going to court and designating him as unable, exactly, unable to make decisions for his own. But as long as he can have a limited conversation, then they have refused to allow me to make those changes. So I don't know what to do.
Skiles, you were about to say something.
Yeah, so you've got a couple of different big issues there. So the first big issue you have is talking about the medical type situation. So power of attorney, healthcare surrogates, and that type of thing. So your healthcare surrogate that you have, even though it's 15 years ago, it's still valid. And if you redo a new one, it's still going to be the same thing that you have now, which says you can make medical decisions for him as long as he doesn't override you. Because you can't say, go have this procedure, go have this surgery, go do this, whatever it is. And if he says, no, I don't want to do that, the doctors listen to him because he still has the right, just like you said, he still has the right to make that decision. A power of attorney, a healthcare surrogate, gives somebody else the ability to assist somebody in making decisions and to do things on their behalf. But it doesn't give you the ability to make a decision for him that he doesn't like. Okay, so you can't force him to go to assisted living. You can't force him to go have an ultrasound, an MRI, or whatever. And I hate to use the word force, but you can't make him do it. All right, you're not. I mean, think about when you got kids and such. The parent can say, "You're my 5-year-old. You're going to go do this," right? Because the parent is in charge and you have the right to make that decision. The kid does not have the right to not listen to the parent legally. I mean, some of them talk back. That's a whole different story, right? But once somebody gets to a point, and you said a magic word there that said dementia, that is a incompetency type situation where he may not really have the ability to really make his own decisions anymore. So what you're really talking about is a guardianship issue. And it's in the probate and estate planning world, so we can discuss that, but it's really a guardianship issue that says, and like you were talking about going to the court to declare that, that's the process you would have to do. You would need to go to the court to say, Judge, Dad has got dementia. Dad has got these physical issues as well. Dad can't really make his own decisions because it's affecting his health for these reasons. And you're asking the court to say, I want you to declare Dad to be incompetent, not able to make his own decisions. He's an incapacitated person. And then once that is determined that he's incapacitated, and there's a whole process for that where the doctors and social workers and such will come interview Dad to agree or not agree that he really needs somebody to take care of him. Once that is determined that yes, he is incapacitated, then you're also asking the court, okay, Judge, since I was his power of attorney and I was his healthcare surrogate in the past, I'd like to be named as his guardian. And you're asking the court to be his guardian, or you can call it parent, right? So you're now in charge of Dad if the court appoints you. Then you can make that decision. Then you can go to the doctor and say, I'm now the guardian. Here's the order that says I'm in charge of dad, and I'm making the decision that he's going to have that ultrasound, MRI procedure, whatever it is, and his decision does not matter because you've got the authority to make that decision. Okay, now there's a lot of steps involved to get to that point, so I'm skipping over some of those, but if you're appointed as a guardian, then you can make those medical decisions for him. And then you can also say, I want to have the authority to decide where he lives. And you can then move him into an assisted living facility, even if it's against his wishes. So then that way you'd be able to get him enrolled in that assisted living, move him into there. If he just refuses, then you ask the court to have the sheriff take him over there. I mean, so there's ways to do all of that. And I say all these things because we've had to do all those things, right? So once you get dad into the assisted living for his own benefit, now let me answer the other question that you had, is you were talking about putting your name on the deed of the house. I will say, don't do it. Don't put your name on that deed for a number of different reasons, okay? One of them is for financial reasons. If he bought that house many years ago and you add your name to it with survivorship, or add your name as a ladybird deed, and then he passes away, you now own a property that I'll use a term called cost basis, which is the cost that you bought the house at is whatever he bought the house at. How long ago did he buy it?
60 years.
Right. So he probably bought it for $10,000 or something like that.
Yeah,
Right.
$13,500.
Right. So this $13,500 house is now worth $200,000-$300,000 or something like that. Right. Or more. You know. So if you put your name on that house as an ownership, your cost basis reverts back to what your dad's was if you do that survivorship type deed. So I don't recommend doing a survivorship deed, because then you turn around and sell it after he passes away. You've got capital gains taxes from the difference from what you sold it for to what he bought it for. So you're talking about tens of thousands of dollars in taxes on that. Now, if you do a ladybird deed, your cost basis gets stepped up to whatever the current market value is. However, the problem there is the other thing you talked about was qualifying for Medicaid. So doing that deed would most likely disqualify him, or not necessarily disqualify him, but it would be part of that 5-year look back period in Medicaid. And we're getting into a lot of different things, but that five-year look back period says if there's a transfer of property within 5 years, that can be prorated, and he could lose or have to pay back a certain portion of that Medicaid benefit. So there's a whole lot of questions involved with that type of thing. You also mentioned you wanted to avoid probate, and it may not be the best idea to avoid probate, especially if he's going to have all these medical bills. So let me explain what that'll be. Yes, it costs a few grand to go through probate. So I understand that part of it. However, if you try to avoid probate, but he loses out on some Medicaid benefits, that's going to cost you a lot more than what that probate expense would have been. Okay, so a few grand is nothing in the medical world, right? When you're talking about getting medical expenses paid for. The other issue is other expenses and any other creditors that he may have, especially medical bills. So let's say there's a big hospital bill right at the end of his life, because you mentioned cancer and some other things that might be coming up there. If there's a $200,000-$300,000 medical bill that comes about and he passes away, that bill is now a claim against his estate. And if you keep the house in his name, Florida has this wonderful thing that's very hard to understand called homestead. And what you can do is you can go to the probate court and declare that his house is his homestead, and it will be exempt from any creditor claims. And I've had $1 million creditor claims from a hospital stay that was 6 months long. When someone was there, it was $1 million claim in the estate. The only asset that the guy had was his house. And that $1 million claim basically just goes away at that point, because that homestead, they can't touch the homestead because it was in his name and it passes to his kids or his heirs, basically. So typically kids. So it would pass to the kids free of any creditor claims, but you have to go through probate to declare it to be the homestead. Okay, so now I know I said a whole lot of things there. We talked from guardianship to deed transfers to probate and all of that. Does that kind of assist, or does that prompt any additional questions for you?
No, I absolutely got it. I'm a paralegal, so I totally understand what you're telling me. Yeah, I just didn't realize all of those other issues could cause a problem later. So the probation or the probate will take 6 months to a year, depending on what's going on, and may cost me a few $1,000s. But in the long run, it will cost me a lot less than having to pay for all of the other taxes and everything else that can come across.
Right. And Eileen, let me just add another component to this, which is when your father is experiencing dementia, he does not have the capability of transferring, right? And I know you talked about you transferring as the attorney in fact on the power of attorney. From a legal perspective, that could be challenged. You never want to transfer a property to your name as an attorney in fact, because someone can claim that you did a self-interest, that you benefited yourself by making the transfer from him to you. So from a legal perspective, I would bring you to court and have that overturned and create chaos, something that you want to really avoid. So just waiting for, not waiting, but not acting. I would definitely do the consider guardianship, just so you can have the ability to make medical decisions on his behalf, for sure. They will ask, they will want to know about the property, because he does, it's not just guardianship over a person, but it's guardianship over person and property. And they're going to want to know what's going on with the property, who's living there, are they paying for market value, and so on and whatnot. So just be mindful of all of that in the guardianship process.
Okay, perfect.
All right, so Jewel, thank you for your patience. These, as you all can tell, these answers are not simple. I try to make it simple, but I know that, by explaining in detail, it really allows you all to kind of move forward and know in a very informed manner. So, Jewel, if you are still with us, I see you are muted.
Hi.
Hello.
Can you hear me? Yes, so I am Charles's sister, Charles Fonseca's sister.
Okay.
I have a question that he did not bring up.
Okay.
The property in question, the one that he talked about that my mother quit claim with right to survivorship to him.
Yes.
In the last years of my mother's life, she also had dementia. And I had another brother, who took her while she had dementia and had her to put his name, to remove her name from the property. The property was bought, my brother, Charles, and my mother had the loan for the property, paid the whole property off. The property was in both my mother's and Charles's name. When my mother had dementia, I have a brother who took my mother to wherever you go to remove my mother's name from the property and put his name on there. So my question is, what he did is, my other brother found out she had dementia and they didn't report it, but then he had his name put on the property. And then 6 months later, he took her to court to say that she had dementia after he put his name on the property. So what I'm trying to find out is that even though it is a right to survivorship, now that he's put his name on the property, so now it's Charles's and my brother's name. What do we do about that? Because my other brother has no right to the property. He did not contribute anything to it. Like I said, the loan was both of my brothers, Charles's and my mother's. So is there anything we can do about that? Because she didn't get diagnosed until after he put his name on it, which he didn't tell us, which we didn't know until later on. Charles didn't know either. So is there anything we can do about that?
You know, it's unfortunate, Jewel. This happens a lot. Right,
Oh my
Skiles?
God.
It happens a lot. I can tell you case after case that have come across my desk. Yeah, if your mom had dementia at the time that she executed the deed, then you can definitely challenge that and win. However, it's going to be a fight. It's not going to be easy. You're going to have to get the notary involved and the witnesses involved. And they have to testify that basically your mom was not incompetent, that she was competent at the time. However, with that said, the fact that within 6 months he took your mom and to court to claim her as incompetent, I think that's definitely going to help your case. But it's not, you know, you may want to start off with a letter from an attorney to him that basically states, hey, we know what you did and we are demanding that you transfer deed from your name back to Charles and mom's name. That's an easy, simple method if it works. If it doesn't work, you're going to have to take him to court.
Yeah, well, we've already tried that, and he has insisted he's not taking his name off. So I guess, and my mom quit claimed this property to Charles because she knew when she got ill that this brother, the same brother, would take everything she has. And she quit claimed it to my brother Charles when they signed a loan probably 15, 20 years ago. You know, she quit claim with right to survivorship. But unbeknownst to us, he took her in and had her name taken off and put his name on there.
Yeah. The other issue there, Jewel, is that you have to have proper standing to be able to bring that matter. And it would need to be your brother Charles that would bring that issue up. If he was in agreement with your other brother, you would not really be able to bring that issue.
Oh yeah,
you're one of the other kids, so it would have to be something that Charles would have to address. He would have to be the one to contact I would say either a real estate litigation attorney or most likely a probate litigation attorney, or a probate attorney that can handle real estate litigation. It's very confusing sometimes when you're looking for that. But that would be the avenue I would address, or that's how I would go.
Okay, Charles?
He is probably muted.
Okay, yeah, he does have he has taken it to an attorney, but unfortunately, like I said, it's really sad. And so, okay,
Right.
that was my question.
Okay, Joel, nice talking to you.
Thank you.
So H. London. If we can have H. London unmuted.
Hello, can you hear me okay?
Yes, we can.
Wonderful, thank you so much. Yes, I had a couple of hopefully brief questions and to the point. What were your opinions on the online do-it-yourself will estate planning forms? Do you think they're any good? Are they inadvisable? Are those usually the ones that are not enforceable by law? Anything you have opinion-wise on that? Second part is, if not, and the recommendation is truly use an attorney, are there any resources to make it affordable for the average person? And then third, when looking for an attorney, do you have any suggestions that you can make to look out for any red flags? Because, you know, when you're shelling out several thousands up front and hoping you're getting what it is that you need, it's very difficult for a lay person to know if they're getting, for want of a better phrase, a good lawyer, if that makes sense.
Sure, and I can answer real quick. So the online forms, in my experience, and I do probate litigation fairly often when it comes to these type of things, when we see online forms, a lot of times they may say that they're state or the state of Florida compliant, but a lot of times they're missing some of the proper language in there. Also, the online forms, they may ask you some questions and go through some of the different scenarios and such, but a lot of times they don't they're not getting all of the answers. So you may have something that there's holes in it. I've had online forms where, okay, I want this to go here, this to go here, this to go here, this to go here, and then they forget about everything else. So then it's, okay, you got a will that says these things go this way, but you forgot about all these other things. So it just creates more problems than it saves you a little bit of money, if that makes sense.
Yes.
So, and if you're talking about affordable, so there are some folks that do, a couple $100 for a will, and there's some people that do a couple grand for a will. So it's hard to tell online, where you're getting that. But your question in regards to red flags, I would say look for their Google reviews. I mean, that's a big thing nowadays. Everybody looks at Google reviews, and some attorneys will have one or two. Some of them will have, hundreds. I guess, you could buy Google reviews or whatever, but you want to read through some of them, because you can tell whether or not they're just generic reviews or it's actually their real clients that have really said, hey, they helped me out with this and I really appreciated it, et cetera, et cetera.
Right.
The best way to find an attorney is ask your friends and say, hey, who did you go to for your estate plan and such. You can also attend things like this, and you're seeing and hearing from attorneys in the local area. It is very hard to find an attorney because we all have great looking websites, and you never know what that website's going to have. Some people do their own content, some people pay for content. So a website is great to kind of get you in the right direction. I would interview a few of them, talk to them, see what they recommend. And if this guy says it's $200 and this guy says it's $2 grand, what am I getting for $2 grand versus $200? It just depends on what it is. Now, having said that, I don't, an estate plan for $200 is probably what you're going to have to pay online. That's probably very low for an attorney. Let's put it that way. But I would just reach out to as many as you can, interview a few and go from there.
Thank you. Yeah, we did
add for that.
Yeah, any attorney that charges a couple of thousand for a will run. So a will's not going to cost you a couple thousand, and it shouldn't even cost you $1,000. I agree with Skiles. You go ahead, you look online at reviews, make sure that they're actually organic, and ask friends, referrals. Yeah, I mean, I don't really have much to add. Just in terms of red flags, it would just be pricing.
Okay.
I would say the average cost of a will would be between $300 and $750.
And I'm assuming by that you mean for a simple, straightforward will with not necessarily any, multiple properties or anything like that, but just a simple basic will.
So $750 would be if you had a little bit more complexity. So, if it's not complex, it should be more like between $300 and $500.
Yeah, I've had some that I've reached out to that won't speak to me until I pay a consultation fee. I'm like, well, I don't even know if I want to use you yet. So I don't really,
yeah, it's hard because that's, it's time spent by the attorney.
Of course.
Of course. We don't charge a consult, but I understand attorneys that do.
Yeah.
Okay, so I think we hopefully answered your question, H. London.
You did. Thank you so much.
Okay, great. All right, so Paul, you are next. Come on down.
Paul left, so our next is Swelly.
Okay, Swelly.
Can you hear me well?
Yes.
Yes.
Okay, my question is, my family passed away. I am from Brazil and I live in here for 22 years. And all my family passed away in Brazil. My father left some real estates over there. And I want to do as one foundation. I want to create a foundation for everything he left, because I don't think I'm gonna go back there, and I live in here. And I started the process looking for how can I create this foundation as I'm over here and I'm there. do I need a lawyer to create this foundation? Another thing is I have a house. I pay mortgage in this house. I was thinking pay off this house and doing one foundation where I can help orphan peoples, not kids, but everyone who lose family, get some kind of help. So that is my thought. I have a daughter. She's living here with her father. She told me she don't want nothing. I can do whatever I want to do. So I wonder, do I need a will to do this? Can I start doing this? Do I need a paperwork for my daughter? Say she not need or she not want anything? How can I do that?
Great question, Sue Ellen. So I do have a question for you before we can respond. So has your father since passed, or is this the anticipation of his passing?
No, all my family passed. My father, my brother, and my mom.
And so I'm sorry to hear that. And the property is in Brazil, all of it?
Yes, they are all in Brazil. It's a small farm in my father's home. So, and I know people there, and my father too was a farmer man. It's a lot of poor people. So one can, I am here, I don't think I need much to think anymore. So I'm trying to do a well or do a foundation in his name and name of my family.
Yeah, it sounds like a nonprofit organization.
Yes.
Is what you need. And I would suggest that you get with an attorney in Brazil, since the properties are in Brazil. But if you wanted an attorney here, then you would transfer all the properties where, you know, you can go ahead and have the nonprofit here, but the nonprofit is the one that owns it in Brazil. But I think that you may find that from a financial standpoint, that it's best to have an attorney in Brazil. Skiles, do you have anything to add?
No, and definitely an attorney in Brazil to be able to do the probate to get the properties transferred properly is probably the minimum that you'll need. I would recommend if you're here and you want to set up to help people. Well, you said you wanted to do the nonprofit, but was that something that you wanted to do in Brazil or over here?
Well, I have my property today. I was thinking the payout of my house. Can I have a house over here in Orlando? And this house too, go to for the organization. So what I think is, my question is, can I do that? Can I pass everything? Should go to me, or it's mine now, to this prof without any paperwork from my daughter, even she's minor. So she say she don't want anything. So if I pay off this house, because now is the bank on, so I'm pay mortgage. So what I want to do here and I want to do there. I'm not thinking go back to Brazil, but yes, during my life, I want to administrate things there in here.
Right, I would definitely set up some type of corporation, either LLC or a corporation or the nonprofit. There's 3 different options that you can have here in the States, and then make sure it coordinates well with Brazil. What you'd probably want to look for is an attorney that has that international relationship, preferably someone that is maybe licensed in Brazil and here in Florida. You also transferring your home here into one of those type of entities might be a disadvantage for you, again, because of that magical thing we call homestead. Because if you're living in it, you get less taxes if it's in your name or in the name of a trust for yourself. So there's a whole lot of things to unpack when you're talking about the different issues that you have. And I would seek an estate planning attorney that has some ties to Brazil, and that can also do some nonprofit work as well. That may be a specific Google search that may be a little more difficult to find.
Yes.
The referral service may have something. Orange County Bar's referral service may have somebody on their list here that may be able to assist you.
Yeah, that was my first thought. And my question is, do I need any proof from my daughter? I don't think so in this point.
You said your daughter's a minor, so there's nothing that she needs to approve of at all.
Okay, there is thank you.
So Ellie, something to also think about is putting your property into a trust. You can still maintain homestead protection as long as you are in touch with the county and letting them know, showing proof that you still own the property, and making the nonprofit or some foundation or maybe an existing foundation that you make them the beneficiary upon your death. So that, you can go ahead and maybe right now create one that exists, but you can always modify your trust to go ahead and reflect a new nonprofit that maybe you create.
I'm sorry, I misleading. So I will create a LLC or corporation and add this house and this property I have right now to that one with my trust or my name. I'm sorry.
So you actually are moving your property into a trust that owns the property. You are the beneficiary, meaning really you're the owner of that trust, of that property, that one asset. It's a land trust. So you are putting the property into a land trust. You are the beneficiary of that trust. And you just put language in that trust that states that upon your passing, it would go to XYZ. You can put, that as a, nonprofit that does work that you really love, that you're passionate about. And if you were to open up a nonprofit, then you can go ahead and, you can change it and make the beneficiary, the last beneficiary, the one upon your death, that nonprofit, because you may be already doing work while you're living, and now you're moving that asset into there so that you can continue that work.
Yes, okay. Yes, thank you.
A little complicated, and again, just speaking with an attorney that handles trust may be helpful to sit down with you and go through it, because you listen to it once, you retain like 10%, and then more and more you can get it.
Yes, you're right. Okay.
Okay.
Yeah. All right, thank you.
You're welcome. All right, next person is C. Gist. I think you may be our last, C. Gist. Sorry, hopefully you hung in there.
Okay. Can you hear me? Hello?
Can you speak a little bit louder?
Yes, I can. Is that
Thank
better?
you. We can hear you. Yes.
So sorry about that. Thank you
No
guys. Listen,
problem.
I appreciate you guys being tangible. And I wanted to give a little thank you to Rebecca for the information she just gave me as well. I live in Orlando, and my father, he lived in Vegas, and that's where he passed away. So my questions are going to be as general as I can make them about the probate process, if you guys can indulge me. That's okay.
Sure. And did you say Michigan, that he passed to Michigan?
Oh, no, Las Vegas, Nevada.
Las Vegas. Okay. Are his assets in Florida?
No.
Okay. So the state of Florida only has jurisdiction over assets in Florida. So maybe we can speak in general, but we're not licensed in Nevada. At least I'm not.
No. And I figured all of that. So understand, when I got your email, I was a little confused, but I figured I would indulge you guys just with general probate questions, because I've never dealt with anybody passing before so closely to deal with this. And I do have questions that I'm not seeming to really get answers for from anybody over in Vegas. So that's why, if you guys can't do it, I understand. And again, I do appreciate your time, because I know it's well after time to go home. So I appreciate you guys. And if it's something you can't answer, again, I do understand. I'm in the dark, and my father's been almost gone for a year. So I do appreciate you guys.
No problem, Mr. So what's your question?
Okay, one question I have is just in general, the probate lawyer purpose is to do what? And I know this sounds very captain, but I'm really novice at all this stuff. So if you could just indulge my inquiries, I would appreciate it.
Sure, I think Skiles, it is your turn, so.
Sure.
you
So what is the purpose of a probate lawyer? So in Florida, so we'll talk Florida, and many states are similar, but some states are different. So I'll just give you some Florida info. If you're going to do probate where somebody is appointed as the representative of the estate, we call it personal representative. Other states call it executor. Florida law says you have to have an attorney that represents you as that personal representative to help guide you through that process and make sure you're following all the laws. I don't know, again, we don't know Nevada, but it should be in Florida, if you are needing to be appointed, you've got to have an attorney represent you. If you're just asking for a what's called a summary probate here in Florida, then you don't necessarily need an attorney, but it might be quicker, easier, more cost effective to just get it done right the first time than trying to do your own pleadings back and forth with the clerk 7 times until you get it right.
Right. Now understand, I like to learn, so I've read a lot about Las Vegas and even you guys now, as long as I've lived here. So again, I'm just if your story lines up with what I read, we're good to go. And that's where I'm at with it. So I'm not gonna use anything that you guys are saying and throw it anywhere else. This is all personal knowledge for my little brain. Okay, guys?
Go right ahead.
Perfect. Okay. Now you saying that you personal rep or executor per case and per purpose. At any time, as far as a probate lawyer, do you guys ever advise heirs or beneficiaries not to speak to one another for any reason?
I wouldn't say that I typically don't advise any of the heirs or beneficiaries of the estate. If I'm representing the personal representative or executor, I represent that person in dealing with the estate to make sure the estate is taken care of. I don't represent the heirs or beneficiaries. Now I may say, hey, here's a petition for whatever, it means this, feel free to review it. And if you have questions, you may want to find an attorney. I can explain what it says and maybe the terminology, but I'm not going to give you legal advice as an heir because they didn't hire me as an heir for that.
Understood.
Oh, and see, just I'm
sorry, Desiree. I'm sorry, guys. My first name is Kaysen. I apologize. I do apologize. So please call me Kaysen. Thank you, Desiree.
I just be calling people by what I see.
Yes, ma'am. Yes, ma'am.
So Kaysen, I'm always encouraging the person, because just like Skiles said, we represent the personal representative. In rare cases, I will represent everybody if everybody's on the same page and they have to sign a dual representation or what have you. But if they're insistent, I normally will encourage communication between them in a positive way. I actually will communicate with all the beneficiaries and say, hey, this is what you can expect in the process. We'd like to have everybody cooperating. We'd like to have everybody on board. I actually promote unity. I never will tell a personal representative not to speak with someone unless they are sabotaging. It can cause some sort of sabotaging in the case. I can't even think of a moment in time where I've told somebody not to speak with a beneficiary, but I'm sure that, I mean, because what I do mostly is probate. So I'm sure it'll come up eventually. I just haven't encountered that. I'm always trying to get everybody working together because it will actually cost them less. And I want to be efficient. I want everybody to say, Desiree Sanchez was a rock star. She got this done and her communication was great. And she had us working together, not against each other. So is that your experience with the Vegas attorney?
Yeah, it's and just, I said, yeah, but let me just ask one more little question and I'll answer all of it. Okay.
Sure.
Just to piggyback off of that. At any time and my verbiage may be wrong, Skiles, so I apologize for the way I proposed the question to you. I didn't mean as far as would you advise nobody to speak, but at any time,
no, go ahead.
Would there be a reason for, I guess, heirs or beneficiaries not to speak in reference to the attorney? And would you or either of you or have seen a situation when an attorney that was in charge of the estate in that manner not speak to all of the heirs or beneficiaries? Because that is what's going on with me in Vegas.
Right. I don't know why the attorney would not want to speak to you. I'll speak to all the different beneficiaries. I don't have a problem with that. The only time I don't speak with them is if they're represented by an attorney, then I'll speak to their attorney because now I can't speak to the heir. Now, if one of the beneficiaries, when I've reached out to them or start talking to them, if they're belligerent to me or something along those lines, then I'll refuse to take their calls after that. I've had that happen. But for the most part, I would say 80% of the time, everything goes fine. Everybody's in communication. Nobody has an issue with everything. But then that 20% of the time, the heirs can't talk to each other for some reason. And they may want to use the attorney as a liaison to talk with each other. And I mean, obviously that just costs more for everybody to do that. But I always recommend the representatives to talk to the other heirs, typically their brothers and sisters kind of thing. But sometimes they just don't want to talk to each other.
Exactly. Listen, that's great. That answers my question perfectly, because it's what I'm thinking. Like I said, I look young and I act goofy, but I like to know. So
sure.
I feel like I have a general idea of like law. I'm not a professional, but I watch a lot of the shows. I watch you guys, and things just tend to make sense when it's the law, and I love rules. So if somebody says something totally opposite of what you just said, Skiles, and you, Desiree, no matter what state it's in, I kind of, can get where you guys are sitting. So to answer your question, Desiree, myself and my brother have been having issues. Not so much so because we live here, but it's the communication thing, the lack of on that side. So that's only why I'm keeping it general and asking the questions based upon the information I can't even get from over there.
And for time, obviously we're at the end of our session here, but it may be beneficial for you and your brother to retain an attorney to represent you as a beneficiary. And then they'll have the ability to get information and share it with you, and might help speed the process up. Might cost you a little bit, of course, but it may help speed the process up and get things working in the right direction. And maybe they can negotiate a little bit better on your behalf if there's anything to negotiate about. But it may be better to get somebody to represent you to help out.
Definitely working on that, sir. Definitely. Listen, again, I appreciate you guys' time. Hope you have a great rest of the week, okay?
You got it, Kason.
Thank you very much.
Not a problem. Have a good evening.
You as well.
All
right. So I think that brings us to the end here. So thank you for attending our Ask a Lawyer event. Please contact the Orange County Bar Association's Lawyer Referral and Information Service to be referred to an attorney for a free consultation of up to 30 minutes. You may be charged for speaking with the attorney or any services provided beyond the initial consultation. So thank you, everybody, for coming tonight.
All right, I want to thank our speakers. Thank you so much, Skiles and Desiree, for your time and for answering those questions with a lot of detail. We really appreciate you guys. I also want to thank our attendees for joining us. That is the end of our session today. I will be sending everyone a follow-up email with more information on some of the resources that were mentioned today, and some contact information. I also want to share that I added the virtual Ask a Lawyer event information for January. So it will be on landlord, tenant, and real estate law. So you feel free to sign up for that. You can sign up now. But I'll send you guys an email, and I just want to thank everyone for their time, and I hope everyone has a great rest of your evening.
Take care.
Bye, everybody.